Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I am your host. This microphone, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. How are you guys doing today? I'm at this wonderful spot of I leave to go to another country in the morning. And I am ready 0%. I am 0% ready to go to another country tomorrow. And so that's just great. But we're doing it. We're going. And so that's just how that's going to be. But here we are. We're going to talk tonight about Sargon of Akkad. Winning his lawsuit, something I haven't spoken too much about in depth. I've talked a little bit about it. I figured we'd kind of go through a portion of the opinion, really look at the fair use analysis that the court did, and then we'll talk about Sargon's fee motion or whatever, because he is moving for fees, and so, yeah, that's, we'll talk about those things. No, I'm not going to postpone for EVS's stream. That's fine. I can't. I can't go later tonight. I would have to postpone it to a different day, which would be like Tuesday. So, no thanks. It's fine. I will just do my stream at the time I always do it. But yeah, we will go through that document. I want to talk about a couple other things. I got into a little spat with very briefly with Jay Woolman, superstar Jay Woolman, who's representing T. Greg Doucette in the legal defense of a DMCA takedown. Very, very strenuous DMCA takedown of Greg Doucette. And I thought, what better day to get into a spat with that guy than on the day when we're going to be talking about a DMCA takedown of a YouTube video in which I think there's some important comparisons to be made. See, the interesting thing about Sargon and Akilah is that Sargon's going after the fees from Akilah because Sargon says that Akilah pursued her lawsuit in bad faith and did it for self-promotion and all sorts of other stuff, which is a little interesting for T. Greg, because he apparently, I'm not saying that T. Greg tried to use the silent sham thing, which was the work of other lawyers, getting the UNC statute settlement overturned. I'm not going to say it was the work of other lawyers, even though it was the work of other lawyers, but he's trying to use that to raise his public profile, and he's definitely trying to use this DMCA takedown to raise his public profile over that. And then when you combine in that the differences between Sargon's YouTube video and what Greg did, there's some interesting questions. At first glance, people would say, sure, the DMCA takedown of T. Greg's Dropbox account was wrong because that was protected use. But was it? I don't think it's as simple of a question as that. Now, I could be wrong, certainly, and I don't know the outcome. Copyright is not my specialty. I have never claimed to have expertise in it, but I think there are some interesting comparisons between Sargon's video and T. Greg's case, and man, that case is also in sort of a jurisdictional limbo right now, so that's really interesting as well. So I'd like to talk about that a little bit also, and we can see what's going on, but yeah, So that's the agenda for tonight. There are some super chats I want to get to right away. There's a really big one, which I was not expecting at all, but very, very appreciative. So we'll get to that one in just a second. Right now, I'm getting the I'm getting the Sargon documents pulled up. I don't want to misstate stuff. Here we go. And I did a video earlier. Let me get this out there right now. Funimation has requested for an extension on filing their response to Vic's appellate brief. Their extension will almost guaranteed be granted by the court, and that will extend out Funimation Only's deadline to March 31st. March 31st of 2020, which will push back the overall ruling in this case. It's assuming there are no other delays. I mean, the earliest we're going to see a ruling from the appeals court is probably somewhere in June. And that's if things move pretty quick. That's less and less likely. Hopefully during summer we'll get some sort of ruling on this, but there always could be delays. But I put out a very short video just mocking the idea that delays are some sort of indicator or nefarious thing earlier. You can check it out. It's just like 6 minutes or something. But I wanted to make sure and keep people updated on the situation, as well as poke fun at T-Greg, who, remember when Vic's team asked for a delay, tried to make it out like they were begging for extra time, which is the stupidest thing that he could have done. So that's why I made that video. I'll let you guys know, I also recorded another video today. If you are a channel member, or a Patreon subscriber or whatever. So if you're either in my Discord or if you have a channel membership here on YouTube, you got the opportunity to preview the 2 videos I did today, and those previews remain live until the videos actually go up. Sargon's video is a little bit longer, and it's a little more in-depth analysis of the memorandum of law in support of his request for legal fees. And I say it's a little more in-depth. It's not the thing where I go through and read every single line. It's really just hitting highlights of important points in the document. So that video will probably go up tomorrow. There's some issue with it right now. I have no idea what's going on, but last I checked, it said it was still processing, which is great, because I certainly don't want my video to like be viewable. That would be just stupid. But apparently I don't know. I don't know how to fix it yet. So I gotta either get it fixed on YouTube's end, or I've got to re-upload it. One of those two things. Really, really irritating. But either way, it'll go up tomorrow while I'm on the plane, probably, and then that'll be there. So you can check that out if you want and share it. It's my take on the Sargon fee thing. But tonight we're not talking about the fee thing. We're talking about the actual case. I mean, we'll probably talk about the fee thing also, but mostly about the actual case and the order for dismissal. So, by Dick Sullivan, judge. So anyway, this is going to be a fun sort of stream, I suppose. Very laid back, and that's the idea about this one. So let's start with these super chats that are waiting, and then we'll get into the stream proper as we go. So again, that first one from Daniel Thomas, very large donation. Thank you. Thank you so much for that. He says, "Hey Boomer, I recently received a surprise class action settlement from a previous employer. I'm splitting it 3 ways between you, my wife, and I." Hey, thanks, buddy. That's high marks. Cheers, buddy. Get Lady Racket something nice. I enjoy your content. Keep it coming. Oh, and try not to be so late and gay. Thanks. I'm sorry. Even in the stream, I failed. But I apologize for failing. I can tell you why I failed. I was going to be on time today, but I let my son play Minecraft on my computer. And for some reason, he shut down my computer when he turned off Minecraft. I don't know what the plan was there, but everything that was up on my desktop, gone. So, that's great. DOG Beerus says, Nick, at what point does an offense go from civil to criminal? Well, if as soon as there's a statute that makes it a criminal offense. That's the trick. It doesn't ever transition from criminal to civil, or from civil to criminal. It can be either civil or criminal, or it can be both civil and criminal. A murder suit can be a wrongful death suit, or a murder case, I guess, a murder criminal case could be a wrongful death civil suit. It all really just depends on whether or not the facts of the event fit, criminal or civil trial, and any statutes that may be out there for that, or the common law understanding of a tort for personal injury. Given what happened with Kitchener Comic-Con, could the people making threats be arrested or only sued? Hey, I wouldn't want to be in the place of threatening anybody or saying any of this stuff in Canada. That's the crazy thing. Canada does not have the same type of defamation protections that the U.S. has. They don't have a First Amendment, and their free speech rights are not the same. So something that might be hyperbolic and not taken seriously in the U.S. could be taken differently in Canada. They could, in theory, be arrested or sued. It really depends. But it depends where they are making the threats, right? If it's some guy in Ohio making a threat to a Canadian convention, I mean, Canada's not going to send Mounties down to Ohio to arrest the guy. But if it is someone in Canada breaking a Canadian law, they could be subject to arrest if there's an investigation, if there's a police report, and all of that stuff that goes into it. Is there any way to deter this type of behavior in the future? No. That's the beauty of it, right? There's no way to deter any of this other than, I mean, if you could get a civil lawsuit, or if people would be criminally charged for stuff, it might be a deterrent, but it's really hard to do either of those things. It's really expensive for a civil lawsuit, and criminal charges are just typically unlikely on the average day for the average person, even when they're doing other than average activities, like maybe threatening to rape a minor, for example. But the question would be, was that intended to be a threat? I think so. It seems like it. Seems like that would be that would qualify as the things we should stop through the law type of speech. But it's not up to me. Next, rando number 9 says, "Bruh, how do you lose your case during Black History Month?" Who lost their case during Black History Month? Oh, Akilah. Oh, that's funny. That's terrible. Because it's a bad case. I mean, that's the real answer, of course, is that it's a bad case. I didn't even realize who you're talking about. Why you do this? Why you do this? JCF Data says, Nick, looking forward to meeting you at Kitchener Comic-Con this weekend. Excited you're coming to Canada. Me too. Me too. The last time I came to Canada, I only had 2 children, and now I have 5. But I brought 2 children to Canada. I'm not bringing 5 children to Canada. So there is that. But yeah, I'm looking forward to it. Come find me. Come hang out. If you want me to sign something, bring something. Come. Just come to Kitchener Comic-Con. Make the event fun. Let's show these losers like that people can just get together and have fun, right? I'm not going to be talking about, in case anyone's curious, I've got 2 panels at Kitchener Comic-Con. I am not going to be talking about the Vic lawsuit at the con. When I talk to Vic, I'm not going to talk about the Vic lawsuit with Vic at the con. I'm going to hang out with my buddy and I'm going to have fun at the con. We're going to be there with a bunch of people who want to have fun. And by the way, if you come to it, I know a lot of people when they get to see Vic, because I've seen this play out, they want to talk to him about this stuff. He probably, as a thought, I just called him a thought, so we'll go with that. As a thought, he probably does not want to talk about and dwell on the ongoing drama that's been pervading his life for a year while he's at a convention. He wants to hang out with people. He wants to see fans. He wants to see all of that stuff. Like, he wants to do that. That's what he wants to do. So if you come hang out with me, come hang out with him, resist the temptation to talk about all this stuff. You know, just be there. That support is the stuff that he wants and needs, and that is valuable time that he gets to spend with people doing what he likes to do, which is hang out with you guys at these conventions. He likes to do it, so do that. Do that. That's my only request. If you want to come talk to me about whatever, I'm game. We can talk about anything. But as long as we do it, let's have fun and try and find some whiskey or something and just have a good time. But at my panels, I will not be talking about the Vic suit or anything like that. I will be talking about a couple different topics. One of them, I will be joined by Ty Beard, and we'll be talking about Warhammer 40K and specifically Games Workshop, and it's like sort of business model, its recovery. If you guys don't know, and around 2006, 2007, Games Workshop was in a world of financial trouble and came close to going under. So we'll be talking about most of that stuff, or that stuff mostly in our chat. And then my chat on Saturday will be completely different. I haven't finalized it yet, but I'll bring something good for you. I'll bring something good. Yes Man 2044, the Sargon stuff, some of the Sargon stuff is in its own small video that will be up tomorrow. It'll be up tomorrow. And it's already recorded, but there's an issue with the upload, and I have to either find a way to fix the upload or I have to upload a new one. But either way, we'll get it released tomorrow. I don't know what the deal is, some glitch on YouTube's end. But it'll be up tomorrow morning, and it'll be out there. But we're going to talk about different stuff than that video tonight. So if you're interested in Sargon stuff and watching tonight, watch the one tomorrow. It will be a different thing. It's not as long, for one thing, and of course it's a little bit more focused on specific issues. Tonight we're going through the actual suit. That's the motion for dismissal. So let me just make sure. Let's see. Here we go. I'm just pulling, I'm just making sure nothing has happened since I got these documents. Because I technically didn't check today, but oh, hey, there's the response is due no later than March 4th. So that's the so we'll be watching this thing over the next week, because we will get to see Akilah's response. So, okay, finally, RZEQDW says, the stock market crashed. My work sent an email that sounds suspiciously like a coronavirus cover-up, and Russia provoked a hot war with NATO today. We're all going to die. I'm still not joking. You are trying to make the coronavirus into something to depress me, and I will not be depressed by an epidemic that ends the world. I won't do it. You can't do it to me. You cannot. Look, if the world ends in a violent flu epidemic, then the world ends in a violent flu epidemic. But that can't happen yet, because Ginsburg's not allowed to die until we determine if Trump will be the next president for the next 4 years or not. So we've got at least 4 years, because even if they have to cure coronavirus to keep Ginsburg alive, they will. You understand? All right, now that we've solved that issue, let's get some proper Irish whiskey going. What do you do with a rare bottle of whiskey? You drink it. Look what Lady Rackets did to me. Look what she did to me. I blame her entirely. Do you see that? Look at the... She left this on my desk where I couldn't see it. This is entirely her fault. And she was on the show the other night, and so I had a monitor turned so she could follow the chat while we were talking. And she left that glass in front of the monitor. I couldn't see it, and I didn't bother to look, and I turned the monitor back around to face me, and it knocked the glass onto the floor and broke it. An absolute atrocity. Gelth Walker says, Rackets, should I drink that rum to kill my cold, straight or as a mixer? Straight. Don't mix it. Don't mix it. If you're trying to kill a cold, you definitely don't mix it. Tell Vic, much love from Australia, and to hurry up and get back here. I will do that. All right, let's do this. Oh no, I still have Sargon's smug little face. I found a smug face for Sargon for the other video. look at the look on his face. Hold on, I'll bring it back. I love it. By the way, a lot of people probably get the wrong idea. They probably think that I don't like Sargon or whatever. I like Sargon. I think he's funny. I've watched his content for years. I haven't watched it a lot in the past year and a half or so because I just don't have as much time, and I don't consume as much content generally. But I think the guy's funny, and I don't wish anything bad upon him. But he sure can look like a smug asshole from time to time. There's no curing that. Oh boy. Anyway. But no, I'm glad he won his lawsuit. Now I have disagreements with Sargon over lots of things. Specifically, I was more on the side of Dick Masterson when he was having a dispute with Sargon over Sargon's excommunication from Patreon. I think there's some unanswered questions there, but you know, disagreements are just disagreements. And by the way, Sargon, if you want to come on and talk about this, buddy, wide open. Would love to have you on. Love to talk about this and all sorts of other stuff. I think you're a funny dude, and I got no bad feelings towards you. No, I haven't read Locke. What am I? Some sort of autist? Siren Jag says, here's a hint. If you're staying overnight at Kitchener, pack a roll of your toilet paper. You probably shouldn't trust the frozen land of hockey and lumberjacks to have reasonable TP in its hotels. Of course I'm going to be overnight in Kitchener. I'm going to be there 3 nights. So anyway. let's dig into this document. So this is the order. This is the dismissal order for Akilah Hughes versus Carl Benjamin, aka Sargon of Akkad. And John Doe's 1 to 10, mate. That's here it is. This was issued February 3rd, so we're pretty late and gay to this ruling. Like I said, I've mentioned it a couple times, but I do think it's really an interesting decision. I'm not going to read through the backstory. I'll summarize the background and the infringing work. We'll probably summarize that. There's a takedown notice, counter notification, procedural history. We'll probably start here at this procedural history just so we get the facts on where this case started, how it's been through the courts, because this thing has moved really slowly. This was filed back in 2017, so it's been a slow-moving process on this case, and I want to make sure we cover that, because this thing, I mean, this is a simple copyright case, right? 3 years almost, well, 2.5 years. Is a crazy amount of time, but that's how it goes. So we'll hit this procedural history, and then we'll go through the fair use analysis, which is a really important part. And there's some pretty alarming statements in here that I think are broader than what they actually normally mean. I think this is a good ruling. Don't get me wrong. I'm not criticizing the judge, but he makes some pretty broad statements in here that I think can be used in the wrong way. Obviously, this is a district court level case and not an appellate case, so it's not precedental. It does not actually change how the law is applied, but it does give some indications of how this works. Also, you will notice that this is a YouTube copyright case, and it is being fought in the Southern District of New York, not in the Ninth Circuit, not in California, because unlike some people out there, jurisdiction is proper where the transaction occurs, not proper just because it happens to involve a third-party company like YouTube. Jay Woolman, T. Greg Doucette. I've got to take a moment and really hope that Jay Woolman and T. Greg Doucette win their jurisdictional arguments. Because, man, it will pain me to make fun of those dumb assholes for filing suit in California if they get the jurisdiction bounced because their case should have been filed in North Carolina. It will cause me physical pain. I will grieve. I will suffer. And I will be laughing the entire time if super attorney Jay Woolman and Low T. Greg cannot together figure out that that was jurisdictionally idiotic. God, that would be the funniest thing on earth. But I'm holding out hope that they win so I don't have to do that. Chuck Keyworth, I did schedule the stream. It just wasn't... I got the link up around 9:30. 9:30 to 9:40. It was a little bit later than normal, but it was still scheduled ahead. Sorry, buddy. But anyway, so here's the procedural history. The North Carolina thing is about T. Greg's Doucette's case, which we're going to talk about in this video also. Oh my goodness. So procedural history. This is Sargon's case. Akilah Hughes sued Sargon. Oh, let me summarize it real quick. Sorry. Here's what happened. After Hillary Clinton lost the 2016 election, Akilah Hughes, or Akilah, obviously, as she is known on her YouTube, as her YouTube name, Akilah obviously lost the case. She did a video called "We Thought She Would Win." Right? That was her case about, or her video about why she, speaking for we, being, I guess, feminists or something, thought Hillary Clinton would beat Donald Trump. Sargon made a video called SJW Levels of Awareness in response to We Thought She Should Win. And what he did was he clipped out approximately 3 segments for just under 2 minutes of content, and he put it together, and it was, you know, it was just him mocking Akilah for thinking that Hillary Clinton was going to win the suit, along with a whole lot of other people who thought they were going to win the election, along with a whole bunch of other people who thought that Hillary was going to win the election as well, right? She's not alone in this, but Sargon is making a point about how SJWs view the world. That was the whole thing. So he makes this video. He doesn't say anything. He just has 3 direct copied clips from her video played, and then that's it. She DMCA's it as a copyright infringement. He files a counter notification, says this is fair use, and then she ended up actually suing him for copyright infringement, which that's how DMCA is supposed to work. They file the DMCA takedown, so then YouTube takes down your video. This is a part I disagree with, but YouTube takes down the video right away, and then they give you time to file a counter notification. You file that counter notification, and then they give them time to respond to it. And that response tends to, or is supposed to, include a lawsuit being filed. And if you file a lawsuit, then they keep the video down pending the outcome of the lawsuit. If you don't file a lawsuit, they're supposed to reinstate the content, because once the counter notification came back, you've given up on it, so to speak. Now, you don't need to do a DMCA counter notification or counter notification to bring suit for copyright infringement. You don't have to do that. The DMCA is a separate process that takes place, and you don't need to have it involved to do a lawsuit. And not doing a DMCA doesn't prevent you from doing a lawsuit or anything like that. But in this case, we have one. So she actually did sue him for copyright infringement. That was back on August 25th of 2017. And now on February 3rd, we have a ruling. So here we go. Hughes initiated this action for damages and injunctive relief on August 25th, 2017. Her complaint sets forth 2 causes of action. First, she asserts that Benjamin infringed on her copyright of We Thought She Would Win through his public posting of SJW Levels of Awareness on YouTube and Twitter in violation of 17 USC 501. That's the Copyright Act. Second, she claims that Benjamin engaged in DMCA misrepresentation in violation of 17 USC 512F by stating in his YouTube counter notification that SJW Levels Awareness was fair use, entirely transformative, and intended for parody. On April 20th, 2018, Benjamin filed a motion to dismiss Hughes's complaint pursuant to Rule 12b6 of the Federal Rules of Civil Procedure, and on the ground that it failed to state a claim upon which relief can be granted. I've said this before, a 12b6 motion in civil case is pretty much pro forma. Like, you just do it. It's part of the process, because if you get it, you win. So you make the argument, you make the motion, and say, this shouldn't even be in front of this court because they didn't make a claim that says they should get nothing. And when you win, you win. It's great. Hughes filed an opposition on May 18th, 2018, and Benjamin filed a reply on May 30th, 2018. On June 7th, 2019, a flipping year later, look at this. Nothing happens. I'm looking at Pacer right now at the docket summary, and literally nothing happens between 5/30/2018 and June 7th, 2019 until the letter is filed. Oh my goodness, the court system is not broken at all. And then from June 10th of 2019, there was a change of address filed for Akilah Hughes, and nothing was filed after that until February 3rd with the dismissal. Nothing happened for basically 2 years of time. Just nothing, though. Just nothing happened. It just sat there. So again, any of you guys who think that Vic's suit or any other lawsuit that we watch on this channel is moving slow, Sargon's case had no documents filed for 13 months and then didn't have documents filed after that for another 8 months. Just amazing. Anyway, on June 7th, 2019, Benjamin submitted a one-page letter in support of his motion to dismiss, apprising the court of supplemental authority. That was probably a reminder. Hey, just so you know, court, we do have an active case here. I'm not joking. We've got some extra authority here. Issue a ruling. There was a change of the judge, so a new judge had to hear it. Still, it doesn't matter. Oh, yeah, I do remember that his judge got reappointed, but still, nothing happened. Just nothing. When did that judge change occur? The judge who ruled on the case, the letter in June of 2019 was addressed to him. The letter filed, get this, there was a letter sent to Judge Richard Sullivan, the guy who ended up writing this opinion. The same judge was filed in April 20th of 2018. So even though there was a new judge to hear the case, it's important to remember that that new judge was on there. That new judge was on there for almost 2 years now, at least. It's amazing. Amazing how long this is taking. Nix Hex says, I didn't catch the whiskey stream live, but instead watched it today at work. Here's a 20 for the hilarious Lemoyne movie quotes alone. They had me rolling, and the laughter you bring me is keeping me going. Oh, man. I hope there's more keeping you going than just that. But, yeah, we should do more Lemoyne movie quotes. All right. So the legal standard, how to survive a motion to dismiss. Pursuant to Rule 12b-6, a complaint must provide the grounds upon which the claim rests. Specifically, a plaintiff must allege enough facts to state a claim to relief that is plausible on its face. This is the Twombly standard. You'll notice it's citing Bell Atlantic Corp versus Twombly. Another popular case in this line of cases is Iqbal versus Ashcroft. Oh, that's cited just down here after that. A claim has facial plausibility when the plaintiff reads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. Does this sound familiar? Does it sound kind of like a prima facie case? If you followed Vic's case, the federal courts all have, basically a prima facie case must be presented in the complaint, right? Enough facts to state a claim to relief that is plausible on its face. The difference between a prima facie showing in federal court is enough facts to show, to state a claim to relief, blah, blah, blah. In the TCPA, they have to provide, they have to do the same thing, but they also have to provide clear and specific evidence of each element of each cause of action, right? So it's a slightly higher bar than federal pleading standards, but it's the same thing. It's a prima facie showing. So a claim has facial plausibility when the plaintiff pleads factual content that allows the court to draw a reasonable inference that the defendant is liable for the misconduct alleged. That's Ashcroft versus Iqbal. In reviewing a Rule 12b-6 motion to dismiss, a court must accept as true all factual allegations in the complaint and draw all reasonable inferences in favor of the plaintiff. Again, same thing. However, that tenet is inapplicable to legal conclusions. So you don't get to say they assaulted me, because that's a legal conclusion, right? You can put a bunch of facts that lead to the idea of an assault or lead to the conclusion of assault, but you can't say they did this thing. They defrauded me is a legal conclusion. They did this thing to deceive me. I provided money to them in reliance upon the deceit. Therefore, they got money from me through false means. That's, that would be like laying out a fraud case, for example. Okay, thus a pleading that offers only labels and conclusions or a formulaic recitation of the elements of a cause of action will not do. If the plaintiff has not nudged its claims across the line from conceivable to plausible, its complaint must be dismissed. Discussion. The court will address Hughes's claims of copyright infringement and DMCA misrepresentation in turn. First, copyright infringement. To establish a prima facie case of copyright infringement, hey, there it is, prima facie. A plaintiff must demonstrate 1, ownership of a valid copyright, and 2, copying of constituent elements of the work that are original. A defendant is deemed to have copied constituent elements of the plaintiff's work where 1, the defendant has actually copied the plaintiff's work, and the copying is illegal because a substantial similarity exists between the defendant's work and the protectable elements of plaintiffs. The defendant can defeat a prima facie showing of infringement, however, by proving that the doctrine of fair use permits his or her employment of the plaintiff's work. So fair use is an affirmative defense. So an affirmative defense, I've talked about this before, but an affirmative defense is where you go and you say, I did the thing. Actually, technically you say, if I did the thing, I was justified in doing it because of this. But you say, I did these things and I could do these things because doing these things was right. It's right here. Now, affirmative defenses can be laid out in a statute. They can be, they can be part of the common law generated over the jurisprudence surrounding a particular issue. They can be all sorts of things. You can create new ones. You can create new affirmative defenses. It doesn't work as well as you might think, but you could certainly try. But there is no like specific list of affirmative defenses that is exhaustive, because you can assert a bunch of affirmative defenses and whether or not they apply or even exist can be determined by the court. All right. Although fair use is an affirmative defense and thus the defendant bears the burden of proving it, fair use can nevertheless be adjudicated on a motion to dismiss. At this stage of the litigation, the court's task is to determine whether the facts necessary to establish the defense are evident on the face of the complaint, including any materials properly incorporated into the complaint. So you can use the complaint itself to establish a fair use analysis. And this is indicative of the real downfall of Akilah's legal case here, is that in her complaint, she puts in some statements that lead to the conclusion of fair use. And we'll talk about that. In undertaking a fair use analysis, the court considers the following non-exhaustive list of factors set forth in 17 USC 107. So these are the 4 main ones. There are other factors they can consider. There's something like 12 or 20 fair use factors that really come into it. These are the 4 that they really hammer on as the critical ones of the analysis. First, purpose and character of the use, including whether such use is of a commercial nature or is for nonprofit educational purposes, the nature of the copyrighted work, the amount and substantiality of the portion used in relation to the copyrighted work as a whole, and the effect of the use upon the potential market for or value of the copyrighted work. So, importantly, they will consider all 4 of these factors. No single factor is dispositive, although the most weight is placed on the first factor as far as transformative use goes, and we'll get there in just a minute. As the Second Circuit has explained, the 4 listed statutory factors in Section 107 guide but do not control the fair use analysis and are to be explored and the results weighed together in light of the purposes of copyright. The ultimate question is whether the copyright law's goal of promoting the progress of science and useful arts, not unuseful arts, hentai is a useful art, would be better served by allowing the use than preventing it. The court will consider each of the above statutory factors. So it's going to go through the 4-part analysis in its decision. And this is where I'll start drawing a little bit of comparison between Sargon's case and T. Greg's case, because I think there's some interesting questions to ask here. Delicious. Purpose and character of the use. The first factor, quote, the heart of the fair use inquiry concerns the purpose and character of the allegedly infringing use. In the preamble to Section 107, Congress identified, quote, criticism, comment, news reporting, teaching, scholarship, and research as illustrative purposes of a fair use. Additionally, the commercial use of the new work, quote, may weigh against a finding of fair use, which favors nonprofit educational purposes. But because, quote, nearly all of the illustrative uses listed in the preamble paragraph of 107 are generally conducted for profit in this country, courts do not give much weight to the fact that the secondary use was for commercial gain. Okay? So, commercial use, did you make money on it? It doesn't. I mean, it matters a tiny bit, but on balance, it really doesn't matter a ton. The most important questions are, is this transformative? Not whether it's profitable. Oh, excuse me. Goodness gracious. I think I talk too fast. Maybe I should slow down so I don't have... I think I talk too fast and my body tries to catch up with the breathing. All right. Where were we? Instead, the critical question when applying the first fair use factor is whether the new work is transformative. TCA Television. Like the overall fair use determination, whether work is transformative is an open-ended and context-sensitive inquiry based on how the work in question appears to the reasonable observer. The critical inquiry is whether the new work uses the copyrighted material itself for a purpose or imbues it with a character different from that for which it was created. Okay? Most relevant here, a new work may be transformative even where it consists entirely of portions of the original work, or indeed even where it is an exact replication of the original work. A secondary work can be transformative in function or purpose without altering or actually adding to the original work. So you can have a transformative work that is a direct copy of the original. That is possible to do. In Baraban versus Time Warner, for example, the court found that the first statutory fair use factor weighed heavily in favor of fair use, where the defendant had copied the plaintiff's photo outright in order to comment on it and on the advertising campaign in which the photo played an integral part. The court noted that the defendant's use of the photo was not exactly parody or satire as those terms have been defined in the case law, but that the defendant's use of the photo in context as part of a book containing critical commentary nevertheless clearly fell within the permissible use categories of comment and criticism. So again, what matters is, are you being critical about the work? Are you commenting on the work in a way that is different than what the work itself represents, right? If a work is funny and your commentary is, this is funny, that's not transformative. If your work is a video of a man getting hit in the crotch with a golf ball, and you point and laugh and say, it's funny because he got hit by a golf ball, that's not transformative. Okay. Interestingly enough, if you're like a surgeon and then you watch the golf ball rocket into the man's crotch, and you talk about the type of damage that would do on the soft tissue of his scrotum, and what kind of restorative surgery that you would have to perform to maybe fix the issues that could come out of it, that type of stuff. That type of analysis could be transformative. You're commenting about the work for a purpose that's different than what the original video's purpose was. All right. So that's the trick. And that's where a lot of the reaction channel streamers kind of fall into the fair use trap. It's not just about their reactions. It's about whether or not their reactions are adding something different to the work than what was already there. Because I don't need I don't need a laugh track. That's not a reaction video that is a proper exercise of copyright or a fair use. A laugh track is not helpful. Do you even I hate laugh tracks. If I watch a show that has a laugh track, I hate every second of it automatically. It's just distracting and terrible. So if your reaction streamer is a laugh track, they could be in trouble on that. Okay, here. It is clear from the face of Hughes's complaint that Benjamin copied portions of We Thought She Would Win for the transformative purposes of criticism and commentary. Beginning with the title of Benjamin's work, SJW Levels of Awareness. Hughes herself acknowledges that SJW, or social justice warrior, is a term, quote, routinely used by Benjamin in a demeaning context to belittle proponents of perceived liberal social policies and stances. That demeaning context right there has just triggered the court to criticism. If it's demeaning, it's critical. It could be pejorative or parody. So it is. This is a problem with her complaint straight away, because she's given the court a reason to say, oh, there's part of the defense. So let's move on. Although Hughes contends that her own subjective awareness of the term's meaning does not establish that a reasonable observer would interpret the term SJW in a pejorative manner, the court concludes that SJW, or social justice warrior, has sufficiently entered the modern lexicon such that there can be no serious dispute as to its pejorative meaning in this context. CEG Oxford University Press, Social Justice Warrior Lexico. So they have an actual definition in a dictionary for social justice warrior. And don't you love when they get those things put in there? And you know they loved having this entry, right? They loved it. Social justice warrior as a derogatory term for a person who expresses or promotes socially progressive views. I'm sure there was just much rejoicing from the social justice community that they finally got it in there and it's listed as a derogatory term. Now it's defined. Now the bigots can eat it. Well, yeah, now we can use it too. And that's citing Laura Wagner. Can you use that in a sentence? Dictionary adds new words, and NPR the two-way. There you go. NPR did that to Akilah. Akilah, you should send NPR a thank you letter for adding social justice to the lexicon of modern America. And then also citing the article by Abby Olizer, I believe, says, why social justice warrior, a Gamergate insult, is now a dictionary entry. Oh, man. Oh, come on. You know that's a good article, right? Oh. I should read it. I gotta read that. See also Nix versus Hedden. This is from 1893, explaining that dictionaries are admitted not as evidence, but only as aids to the understanding of the court. So there you go. And, quote, levels of awareness is plainly used in a sarcastic manner when combined with SJW, implying a lack of awareness concerning social or political matters. Now, some judges like to play dumb. This judge didn't have any nonsense to deal with here. It's clear. He's like, this is obviously, that's sarcasm. It's sarcasm. We got it. Okay? Haha, Sargon with 200 IQ joke makes a sarcastic quip about SJWs. And the judge is not fooled. The judge is not taken for a ride on this. Obviously, he knows that this is a joke, and that is the point of the joke. Moreover, the critical nature of SJW levels of awareness is apparent from the broader context of Benjamin's YouTube channel, where it was posted. Now, this is pretty interesting here, because they're saying, by the nature of Sargon posting something related to SJWs, you know he's opposed to SJWs. So you know that it's a critical perspective because of the source. I think that's a dangerous game for the court to play, but it is reasonable, right? A reasonable person watches a Sargon video and they can't possibly think he's trying to convey the same message as Akilah Hughes. Just can't be that way. Hey, what's up, Sketch? All right. Let's see. As the complaint alleges. Oh, wait. Here we go. There's a footnote. The court takes judicial notice of the news articles which report on the Lexico dictionary entry for the fact of their publication, since the articles predate Benjamin's posting of SJW levels of awareness and thus show that SJW was in a dictionary as a derogatory term at that time. So there you go. The court's like, yep, it's in a dictionary, so it's now we're good. As the complaint alleges, Benjamin, quote, routinely engages and criticizes viewpoints on various social and political issues. That's taken from the complaint. They're making the argument for fair use in the complaint by saying he routinely criticizes viewpoints on social and political issues on his YouTube channels, specifically targeting topics such as feminism, the left, and Black Lives Matter. Thus, whether SJW levels of awareness is accessed by searching for SJW related content on YouTube or by going directly to Benjamin's YouTube channel or in some other way, a reasonable observer who came across the video would quickly grasp its critical purpose. Of course they would. Furthermore, although courts have found transformative uses even in cases involving exact copying, the court notes that SJW levels of awareness is not an exact copy of We Thought She Would Win. Rather, Benjamin exerted We Thought She Would Win to depict the specific moments he felt exemplified Hughes's political identity and lack of awareness. For example, Benjamin included Hughes's prediction and hope that Secretary Clinton would win the election, while omitting footage that did not support his message, like Hughes's statement that Secretary Clinton won the popular vote with record numbers. And he excluded content unrelated to his criticism, like Hughes's commentary on the societal benefits of YouTube. This way, Benjamin exerted We Thought She Would Win to maximize his criticism of Hughes's liberal viewpoint. And then footnote again, to the extent that Benjamin's selective exerting was not fair to Hughes in the colloquial sense of accurately conveying her level of awareness, courts will not, except in rare circumstances, reject a fair use defense based on the inaccuracy of a critical work. So yeah, he wasn't fair to her. He was misrepresenting her case or whatever, but that doesn't matter for fair use. That's not the fair. It's not the fair you're looking for. And if Obi-Wan would have done that with a liquor, he'd still be alive today. Dirk Lamont says, I'm glad that Sargon won this case, but he's still a manlet idiot with an overinflated ego. I wonder what movement Carl of Applebee's will ruin for his next dopamine hit. To be fair to Sargon, I mean, if you convince 980,000 people to subscribe to your channel, it's going to give somebody an ego. I mean, I think maybe he went too far. I don't think YouTubers are fit to be politicians. I really don't. That's me included. So I don't. I hope my ego is never inflated that large. I'd like the subs, but not the other parts. Oh, I know they're dead subs. It's not about that. It's about the fact of convincing almost 1 million people to click a button at one time. It's a hard thing to do. That's an accomplishment. That can give someone an ego for sure. But anyway. But yeah, I mean, he's certainly, again, that would be like if I ran for election, it would be a mess. It'd be a disaster. There'd just be clips of me calling women fat. That didn't work out for Bloomberg, I guess. Apparently you can't do that. So it would just be it'd be a mess. And Sargon has had plenty of moments that just do not play well outside of the context of YouTube. Finally, although the commercial nature of an allegedly infringing work is not necessarily a significant factor, the court notes that the complaint barely mentions the commercial or non-commercial nature of SJW levels of awareness. At most, the complaint alleges generally that defendants have unfairly derived profits from SJW levels of awareness in the form of advertising revenues generated from its upload to and availability on YouTube and from increased popularity of their YouTube channel attributed to SJW levels of awareness. The complaint, however, does not specify how the increased popularity of Benjamin's YouTube channel commercially benefited Benjamin himself. This is one where I think the judge may actually be playing a little bit dumb. She should have explained it, is what he's saying. Should have explained how he makes money. Or maybe the judge just doesn't know because judges are boomers. Let's see. Nor does the complaint indicate whether the referenced advertising revenues accrued to Benjamin or to YouTube. Well, the answer to that, judge, is yes. Yes. It accrues to both YouTube and Benjamin. In any event, insofar as there is a commercial aspect to SJW levels of awareness, it pales in significance to the considerations discussed above. And then this is citing back to that case. Although there is no question that the defendant's artworks are commercial, we do not place much significance on the fact due to the transformative nature of the work. Does it change the work? That's what matters. That's what matters. And ultimately, in fair use analysis, does it change the work matters more than almost anything else. I love Adblock says you should talk to or cover Josh Pilault case. He's the RuneScape terrorist. Very interesting stuff. Wait. What's the RuneScape terrorist? Oh my God. What did I say? Oh yeah. Because a reasonable observer would plainly infer from the title of Benjamin's video, the context in which it was posted, and its selective copying that it was intended to criticize Hughes and comment on her perceived lack of awareness, the first fair use factor favors Benjamin. Look at all those Fs. F. First fair use factor favors. Okay, let's very briefly take a quick pause to talk about T. Greg's lawsuit against the Sons of the Confederate Veterans. All right. T. Greg has said that his sharing of a letter that was published to members of the SCV, that his sharing of it on his Dropbox was transformative. Yeah, I don't know about that. Like, I don't know about that. It's pretty interesting to think about this idea, because on one hand you could say, well, T. Greg is a known anti-racist, and he put them racist boys in the SCV in their place by sharing it on his Dropbox. Like, what does publishing it on his Dropbox actually mean for newsworthiness, for criticism, for commentary? He didn't comment on it. It's not altered with footnotes and criticisms. There's nothing like that. It is a replication of the entire work, posted for the purpose of conveying the information in the letter. And that's what the letter's purpose is. This is the argument you'd make, right? The letter's purpose is to convey the information of the letter from one person to the other. And that's what Greg was actually doing. He was sharing the letter to other people. And interestingly, there's nothing transformative about that. And it's Dropbox. So it's not like there's a contextual analysis that can be made. When you go to Sargon's page, he's got all these videos with his opinions and commentary and all sorts of title changes and stuff like that. This is just uploading the letter to Dropbox. Now, T. Greg has asserted that it's newsworthy, but just asserting it's newsworthy doesn't make it newsworthy. And he doesn't explain... I don't think in his complaint he explains how it's newsworthy. Like, what about his sharing it makes it newsworthy, other than the fact that he just shared it with other people? It's not like he published it to a blog or a news platform. He uploaded it to his friggin' Dropbox. That's not a news source. That's just republication. And he definitely did it to increase his own profile. So, very interesting differences here. And I don't know how the court's going to see it, right? It's an interesting question of, can you do this? But again, what newsworthy purpose is uploading a document to a Dropbox? Like, unless people are going there for their news. It's not his blog that he posts to every day, that he talks about things. It's not a YouTube channel. Hell, it wasn't even his Twitter. It was uploaded to Dropbox. So... very, very interesting differences on that one. Now, for the nature of the copyrighted work, the rest of the fair use factors are a little shorter, I believe, than that first one. This one's only just one column, basically. Second fair use factor, the nature of the copyrighted work, quote, calls for recognition that some works are closer to the core of intended copyright protection than others, like works intended for creative expression for public dissemination. Applying this factor, courts consider whether the copyrighted work is expressive or creative, with a greater leeway being allowed to a claim of fair use where the work is factual or informational, and whether the work is published or unpublished within the scope of fair use, involving unpublished works being considerably narrower. So if someone has created something that is unpublished and you take that is worse. Or the courts look at that less favorably, we'll say. If it's an unpublished work and then you take it and publish it, because the obvious inference there is that you can claim it as your own by publishing it before the other person does. Spectre06 Gaming says Justina Pelletier's family lost their lawsuit last week, and I missed it while doing the series on Kitchener Comic Con. F's in chat for Justina. That's a real tragedy. I'll have to look up that case and maybe we could talk about it. Maybe if you want to, Spectre, if you want to do some digging into it and let me know, maybe we can talk about it next week or something. Because I'd love to talk about that case. It's so horrifying. Okay. The second fair use factor, however, quote, may be of limited usefulness where the creative work of art is being used for transformative purpose. Citing the Bill Graham Archives versus Dorling Kindersley Limited, explaining that the nature of the copyrighted work is not much help in separating the fair use sheep from the infringing goats in a parody case, since parodies almost invariably copy publicly known expressive works. Here, the second fair use factor is essentially neutral and of little import. As for the first Blanche consideration, Hughes's work is factual or informational in that it provides a first-hand account of a newsworthy event, but it also has expressive or creative value in both its commentary and production. So it's both and, which is unuseful. With respect to the second Blanche consideration, we thought she would win as a published work, and thus the scope of fair use in this context is not considerably narrower than it would be if it had been unpublished. Given those countervailing considerations and the fact that SJW levels of awareness is plainly transformative, the second fair use factor has little impact here. And again, drawing some parallels or distinctions between T. Greg's case, the question there would be whether or not the SCV sending letters to its members counts as publication to the publication. Publication in defamation is merely communicating something from one person to another. Publication in copyright might be a little bit more than that. I'm not actually positive on what publication entails in copyright, so I don't know the answer to this. But if the question is a privately shared document being made public, if that is given that narrower look, what weighs in favor of T. Greg is that letter is probably factual rather than creative, and factual stuff is more likely to be fair use than creative stuff. So to be fair to him, that factor that may neutral out, or it may weigh in his favor. Ooh. Sorry, I just breathed some of that whiskey up into my nostrils. Oh, that was magic. Whoo, hoo, hoo. Someone asked what I was drinking. They must have been a little bit late to the stream. This is Middleton Very Rare Irish whiskey. It's a good one. Whew. Okay, so the amount and substantiality of the portion used. The third statutory fair use factor turns on whether the amount and substantiality of the portion used in relation to the copyrighted work as a whole is reasonable in relation to the purpose of the copying. So we'll just read it. In assessing this factor, the court considers not only the quantity of the materials used, but also their quality and importance. The crux of the inquiry is whether no more content was taken than necessary, given the purpose and character of the allegedly infringing use. The third factor inquiry must take into account that the extent of permissible copying varies with the purpose and character of the use. Thus, the third factor may favor the defendant even where the defendant copies an entire work, provided that such copying was reasonably necessary in relation to the work's transformative purpose, concluding that the third fair use factor was neutral where an entire work was copied. So it matters on whether or not you need the entire work. It's hard to copy part of a picture unless only part of the picture matters. But if the whole picture matters for the criticism, you need the whole picture. If it's a 20-second video and the entire video is a clip, like a reaction video, right? Like you're reacting to a 20-second comedy clip, or a Vine for 6 seconds of video in Vine, right? And you're reacting to that Vine. Well, you probably need all 6 seconds. It's hard to trim time off of a 6-second clip, and it's probably just conveying one major theme. If you have a 3-hour-long live stream that has two other subjects, then maybe it's broken up hour by hour by hour. You have one subject in the first hour that you want to talk about, and then the other 2 hours aren't relevant. Well, restreaming the entire thing isn't conducive to your purpose. Okay, so this is a pretty basic sort of understanding. Here, SJW levels of awareness copied 20% of We Thought She Would Win, a percentage which, while greater than that found unreasonable in some cases in this circuit, was still far less than the entire video. In addition, although the selected excerpts were important to Hughes's video, at least as important as any other part of her video, they were also linked to the critical purpose of SJW levels of awareness. As noted above, Benjamin did not copy parts of Hughes's video that undermined or were unrelated to the critical purpose of SJW's levels of awareness. Notably, Benjamin also did not copy every part of We Thought She Would Win. that evinced Hughes's progressive views. Rather, Benjamin copied as much of "We Thought She Would Win" as was deemed reasonably necessary for him to convey his critical message. In these circumstances, the third factor tips in favor of Benjamin. Benjamin. The fourth factor is the effect on the potential market for the copyrighted work. And to me, this is an extremely important factor, although I don't think it gets as much weight as a transformative use. But the question is whether or not the market for each work conflict, right? Like, is Sargon's audience Akilah's audience? No. Maybe more than this judge thinks, but generally no. The fourth fair use factor concerns, quote, whether the secondary use usurps the market of the original work. A defendant usurps the original work's market when the infringer's target audience and the nature of the infringing content is the same as the original. Thus, the more transformative the secondary use, the less the likelihood that the secondary use substitutes for the original. Right? So if they're trying, Sargon is clearly writing this for people who are counter to SJWs, or at least SJW neutral, rather than pro. He's not trying to send this message to Akilah's audience for the purpose that Akilah would be sending it to her audience. Now, I'm sure Sargon wants Akilah's audience to come and watch him smuckle at her loss, right? Like, Sargon wants that to happen. He wants them to and cry and all of that stuff over Trump's election. Absolutely. He wants to do that, and he makes the video to piss some of them off. He's loving the hate views as much as anybody loves hate views, right? That's true. But his target audience isn't them. His target audience is his audience, his fan base, and people who politically align with him or are at least neutral between him and Akilah. He's trying to convince the people that have similar ideas. Here, there is no danger that SJW levels of awareness will usurp the market of progressive commentaries such as We Thought She Would Win. Benjamin's target audience, generally political conservatives and libertarians, is obviously not the same as Hughes's target audience. You know, this judge actually watches Sargon, right? Like, that's the trick. Let's see. Moreover, although SJW levels of awareness comprise entirely of portions of We Thought She Would Win, there's no reason to think that Hughes's audience will abandon her progressive YouTube channel to watch the derisively titled SJW levels of awareness on a conservative YouTube channel simply because it contains parts of her work. Thus, the fourth fair use factor, like the first and third factors, favors Benjamin. That guy from that thing says, seriously, I can be your bootlegger if you're buying high-priced whiskey. I drive to Fargo every Friday. F Minnesota sin taxes. Wait. Do you live somewhere near me? Talk to me, man. Talk to me. Okay. Because 3 of the 4 statutory fair use factors favor Benjamin, including the most important factor, the purpose and character of the use, and the least important factor, nature of the copyrighted work, is neutral, the court concludes that the fair use defense clearly applies based on the face of Hughes's complaint and a review of the video themselves. Accordingly, Hughes has failed to state a claim of copyright infringement for purposes of Rule 12b-6. Sargon should just take a video of a Trump rally and just edit in Trump saying Gamergate over and over, right? That'd be great. Well, that guy from that thing, we should talk sometime. Fargo is... You can't be an hour from Fargo and an hour and a half from Wilmer. That's only 2.5 hours, and Fargo's farther than that, isn't it? Maybe not. Maybe it's not farther. I don't ever go to Fargo. All right. DMCA misrepresentation. So this is the next part of it, right? Akilah alleges that Sargon lied in his DMCA counter notification, and it's a really weak argument. Let's breeze through it real quick. The DMCA allows online service providers to avoid copyright liability if they comply with the procedures set forth in 17 USC 512. Specifically, a service provider may avail itself of the safe harbor provisions in Section 512 by expeditiously disabling access to allegedly infringing material upon receipt of a so-called takedown notice. A copyright owner who submits a takedown notice must include a statement under penalty of perjury that she has a good faith belief that the use of the material in the manner complained of is not authorized by the copyright owner. In response, the creator of the allegedly infringing work may file a counter notification in which the alleged infringer must attest under penalty of perjury that the subscriber has a good faith belief that the material was removed or disabled as a result of mistake or misidentification of the material to be removed or disabled. Upon receipt of the counter notification, the service provider can again avoid liability by restoring access to the allegedly infringing material in 10 to 14 business days. However, any person who knowingly materially misrepresents under the section that material or activity was removed or disabled by mistake or misidentification is liable for damages, including costs and attorney's fees incurred by the copyright holder as the result of the service provider relying upon such misrepresentation in replacing the removed material or ceasing to disable access to it. So, you're only liable for damages stemming from your misrepresentation, right? That's important. You're not liable for all damages, only from the misrepresentation. The guy from that thing, I never speed ever. I've never exceeded the speed limit in my life, except for the few tickets I have received. Like 9 tickets that I have received over the course of my driving career. Those were the only times I have ever sped. Every other time I've observed the speed limit dutifully. And ever since getting my law license, I have only observed the speed limit as I have no tickets. Here, Hughes alleges that Benjamin knowingly and materially misrepresented in his counter notification that SJW levels of awareness was fair use, quote, entirely transformative and intended for parody. These allegations fall short. Benjamin's implied statement that his video constituted fair use, the counter notification itself does not actually use the term fair use, was accurate for the reasons stated in this opinion and order. As a court in this district has explained, it is self-evident that a statement cannot be a misrepresentation for purposes of 17 USC 512F if it is factually accurate. So, if the court finds that it was fair use, then it was fair use. So the statement that it was fair use can't be inaccurate. The same is of course true for statements that are legally accurate. Similarly, Benjamin did not misrepresent that his video was transformative. Whether it was entirely transformative as stated in his counter notification or merely transformative is immaterial as a legal manner. And there's a case here explaining in the defamation context that plaintiff's exaggeration was mere hyperbole or a matter of opinion and not false. Last, the complaint fails to plausibly plead a misrepresentation in the form of Benjamin's statement that SJW levels of awareness was intended for parody. Even if SJW levels of awareness was not, strictly speaking, parody, as that term has been defined in the case law, the difference between parody and non-parodic copying for the purpose of mocking criticism is subtle and ultimately immaterial here. Moreover, it is implausible to suggest that Benjamin knowingly adopted one of these two characterizations over the other in an effort to mask his intentions, because the complaint therefore does not plausibly allege that Benjamin made misrepresentations in his counter notification, let alone knowing and material misrepresentations. Hughes's DMCA claim fails. Conclusion: for the foregoing reasons, it is hereby ordered that Benjamin's motion to dismiss is granted. Although Hughes has not requested leave to amend the complaint, the court notes that leave to amend would be futile. The court's analysis above is principally based on its review of the two works at issue and the context in which they were posted, rather than any allegations that may be refined in amended pleadings. Thus, the dismissal is with prejudice, and the clerk of court is respectfully directed to terminate the motion pending at document number 30 and close this case. Done. Done. Sargon wins. Signed by Richard Sullivan. That is the opinion. That's the part that matters. That is a full fair use analysis. Take it for what you will, learn from it, especially if you are a content creator. It's a very important case for people on YouTube, for people on Twitch, for people on any platform where you might use the work of another, especially when you might ridicule another person. Also, the court is telling us something important here. Always mock and criticize people, because if not, you might be copyright infringing. But if you're mocking and criticizing them, it's hard to copyright infringe. Isn't that beautiful? This is America. That is quintessentially American. Look, I don't you can imagine the founding fathers around the table like, all right, well, we don't want people copying stuff, though. Well, no. If someone worked really hard on like a song or like a rap or whatever, we don't want someone else copying that. That'd be rude. You know, they just copy it and take the work for themselves and take all the glory. Well, what if it's a diss track, though, and they're making fun of them? We're good. Do that. Yep. That's the only kind of copying we want. We want it full of snark. We want it full of insults. We want mockery and criticism. When I can foresee the future and there is a sun that will land on the planet named Tess Holliday, and we want people to reproduce Tess Holliday's pictures, calling that thing out for them jelly rolls and fatness. That's what we want to happen. So that happened back in 1776. That was the debate that actually happened. But yeah, that's there you go, guys. That's the Carl Benjamin lawsuit. I'm not going to go through his fee memorandum. I have it here. You can watch the video tomorrow for that. It's thorough enough. See, I've got highlights. I actually like went through and highlighted the important stuff in the case just for y'all. Y'all can check those out on tomorrow's video. But basically, the long and short is, here, let me summarize their argument. Yo, even the judge said this is stupid, so we should get fees and such. That's it. That's the argument, and it's a great argument. It's a great argument that's out there, and it should be paid attention to. Sargon should get his fees in this case. You know, he did do this on the cheap as far as New York goes. Only 40 grand to fight this. But when you consider how long it took, right? Now, granted, there were long periods of nothing happening, but still, like, a lawyer had to keep up with this case from 2017 to now. So he's asking for just shy of 40 grand, and he should get it. Like, Akilah should not have used the copyright system to go after Sargon in this case, and we want abuses of copyright punished. We really do. We really do. That's the hard part about T. Greg's case is I have a conflict in my brain because I want T. Greg punished because he's such an insufferable pile of garbage, but I also don't want the copyright system exploited for the entire thing, or for silencing of criticism. Now, I want him to lose because I think it'll be funny. That will be much funnier than winning. But principally, you know, it provides a conflict on principle. So, but I do want to point out something. This is that. They have that GoFundMe going, and it is performing very well, as you can see. And yes, if you go through here, you will see some absolute moron saps who have been donating this. Stephen DeLuke, you find that moron on Twitter. What an idiot. That guy is dumber than a sack of bricks, and he was happy to give money to T. Greg. You've got, let's see. I don't know who any of these people are. This is an interesting question. This $3,600 anonymous donation. That would be a shame if that was T. Greg recycling money into the account. I have no evidence to support that. Tyler Wolf, look at this dummy. Oh, good job, Tyler Wolf. Tyler Wolf went on Twitter and bragged about his billable rate being massive, like bigger than Ty Beards and all this stuff. And he's supercharged Geico attorney in Australia. And he was able to pony up a whopping $20. Look at that. Look at that level of support. An enviable amount of money from this very rich, very successful associate attorney in Australia. Whew. Whew. Sneegy Twitter is definitely not a real name. GoFundMe, you need to apply your standards evenly. This is a fake person, and those are not allowed last I checked. Very, very lame that they've allowed that. But we've got anyone else? Oh, Daniel Amsler, the dumbest Canadian paralegal on the planet. Oh, I hope he shows up to Kitchener. That would be great. I would love to make fun of that guy to his stupid face. Oh, that'd be funny. Another anonymous big donation there. Who else do we have? Do we have any other people who are stupid? I mean, I'm guessing a lot of them are, but I don't know that for sure. So I don't want to, I don't want to call out people that Tyler Wolf. Oh, sorry, that 20 was a second donation. His first donation of 25 puts him at a whopping $45. Whew. Oh. I'm glad to have the support that guy's supporting T. Greg. Stephen DeLuke, look at that. Another couple from him. Oh my God. Russ Shackelford, is that Rusty? Rusty Shackelford, did you donate to T. Greg's campaign? I hope so. Oh no. Oh no. Okay. But anyway, they've been, this thing has been going since December 17th of 2019. So we're now 2.5 months into it. They've raised an impressive almost $10,000, and they haven't had a donation in 9 days now. But let's take a peek at a different GoFundMe. This is Vic Mignogna's GoFundMe, $276,045. So thank you all to everyone who has donated to that. Very much appreciated. And we do have a little bit of a time advantage on them, but I will say we are getting donations at a much more consistent rate still. And any donations you want to make to that are, of course, appreciated. I just want to rub it in their face because T. Greg is very, very popular on Twitter, and Jay Woolman is the greatest First Amendment attorney known to man, despite getting BTFO'd on jurisdiction in Alex Jones's case and probably getting BTFO'd in jurisdiction in T. Greg's case. He's the best, the literal best attorney ever, and had all sorts of great advice for everybody. We just can't seem to figure out how to make people donate to a GoFundMe, though. So, rip for that. Can you imagine the level of hand jobbery going on between those two? And they're planning to like, yeah, we'll do a GoFundMe. We're really popular on Twitter. It'll be great. We'll definitely get those legal fees covered. Sure you will, guys. Sure you will. You're gonna do great. I believe in you. I think you'll be very capable because you guys both seem like high charisma, very likable people, not completely hideous, unfunny, soulless monsters at all. No. Oh, no way. I can't teach them the art of the grift. They would never take lessons from me. But just remember, if Jay Woolman loses, if Jay Woolman of the Randazza Legal Group, the greatest First Amendment law firm in history, if they lose, that means that they're a fraud, right? That they're guilty of wire fraud. That's their standard. That they grifted people on a case that anybody should have known was a failure. That's what it means. We'll see. I don't think they're going to lose, though. I think they're going to do just fine. Bringing that in the Ninth Circuit was definitely a move that was going to work. But I look forward to it. Oh, we're following that case. Make no mistake. Actually, speaking of which, I finished the Sargon thing very quickly. Do you guys want to see the response to that? Because the Sons of Confederate Veterans have filed a motion to dismiss based on jurisdiction already. So I could pull that real quick. I have it. Where is that? Where is that? I don't know. Maybe you guys aren't interested in that. Go. Motion to dismiss lack of jurisdiction. This isn't a super long case. We can pull this pretty quick. Oh my. Hold on, I gotta save it real quick. Do shit. Now I have a new folder on my... Oh wait, I already had one. Let's see. Oh, that's his bankruptcy. All right. There we go. Let's get rid of this. I Love Adblock says, sorry, can't talk in chat, so I'll pay the grift fee. Josh got drunk, got told to kill himself, then said he was going to blow up the dude with fire and fury in Minecraft himself. He served 5 years. There's a bit more to it. Sad. Oh, man. That's a great story. Yeah, I'll see if I can get a hold of him. I have no idea how, but I want to know. Okay, so these are attorneys for defendants Ronald Kevin Stone and the North Carolina Division Sons of Confederate Veterans Incorporated. So they filed this in the Northern District of California. Again, pretty odd considering both Doucette and the SCV and Ronald Stone are all in North Carolina. Only Dropbox is in California, but they want this in California, right? Even though it costs way more to litigate there. Nova Zero says, yo, Nikki, tilt just a little bit more to the right, please. Like Miss Rackets just appeared to throw something at your face. Ooh, yeah. Chair Chan. Every time. Look at that. That's all for you, buddy. All right. All right. There was an A10 brap level of cooming going on just then. Okay, so here we go. So they've requested a March 19th hearing on this. So that's interesting. But let's read their motion to dismiss. March 19th, 2020 at 1:30 p.m. or as soon thereafter as counsel may be heard, located in a courtroom to be determined, blah, blah, blah. Defendants Ronald Kevin Stone and Northern Carolina Division Sons of Confederate Veterans will and hereby do move to dismiss plaintiff's complaint against them for lack of personal jurisdiction pursuant to Rule 12b-2 of the Federal Rules of Civil Procedure. In the alternative, should this court find that personal jurisdiction exists, Stone and NCSCV respectfully request that this court either dismiss the case or transfer venue to the United States District Court for the Middle District of North Carolina on the basis of forum non-conveniens. This motion is based on this notice of motion and motion, the memorandum of points and authorities and declaration of Ronald Kevin Stone and accompanying exhibits, pleadings, and other such and upon other such matters as may be presented at the time of hearing. Statement of issues to be decided. So again, this is, everybody has a different style of writing legal documents. This is nice. Here are the issues. Now, when you're in law school, you learn a writing style called IRAC. Issue, rule, argument, conclusion, right? Statement of issues, statement of relevant facts. It's part of the issues. Typically, I guess they're going to combine the rule into their argument, and then the conclusion follows. But let's take a peek at this thing. The issue is, 1, whether the court lacks personal jurisdiction over defendants Ronald Kevin Stone and North Carolina Division Sons of Confederate Veterans. Legal writing tip. Write your questions so that the answer you want is affirmative rather than negative. Oh, you can't see this. Dang it. I apologize. Here we go. Okay. It's, we got it. We got it. Sorry, Reddit. We did it. This is just a legal pro tip. It's a psychology pro tip. People like saying yes more than they like saying no. So when you have, when you're phrasing a question for the court or anybody, phrase it in the way that answering yes gets you what you want. So yes, the court lacks personal jurisdiction over defendants Ronald Kevin Stone and North Carolina Sons of Confederate Veterans. Perfect. The question of does the court have personal jurisdiction over defendants would mean the answer that they would want would be no. Well, it's harder for people to say no than yes, so you ask them in a way that says yes. So, good pro tip. Whether dismissal or transfer to the Middle District of North Carolina is proper under the doctrine of forum non-conveniens, should the court find personal jurisdiction over defendants? Yes. Yes, it is proper. Oh, that was easy. Oh, I can go on with my day. I'm a judge. I'm going to go wearing my robe and letting my scrotum flap under my robes without any pants on. Because that's what documents do. That's what documents do. That's what judges do. Need more whiskey so I can talk clearly. Defendant Sons of Confederate Veterans is a nonprofit corporation organized under the laws of North Carolina and headquartered in Stanford, Lee County, North Carolina. Defendant Ronald Kevin Stone is an elected officer of the Sons of Confederate Veterans and is also a citizen and resident of the state of North Carolina. Plaintiffs to this action are likewise North Carolina residents. Plaintiff Thomas Gregory Toussaint is a citizen and resident of Bankruptcy, North Carolina, and plaintiff law offices of T. Gregory Toussaint is a North Carolina professional limited liability company operated by North Carolina licensed attorney Thomas Gregory Toussaint. Now, obviously, they said North Carolina as many times as possible in these sentences. We've got 1, 2, 3, 4, 5, 6. 6 times in this little paragraph they said North Carolina. Obvious. Hello, this is ridiculous. Why is this in California? This shouldn't be there. On December 2nd, 2019, plaintiffs posted the entirety of a letter defendant Stone created to plaintiff's Twitter account using plaintiff law offices of T. Gregory Doucette's Dropbox account. NCSV submitted a notification of claimed infringement to Dropbox electronically concerning plaintiff's use of the entirety of the SCV letter. Plaintiff Thomas Gregory Doucette submitted a counter notification to Dropbox in response on December 2nd, 2019. On December 13th, 2019, plaintiffs filed the present action against Stone, NCSCV, and Dropbox Inc. in their complaint. Now, notice they apparently didn't. I don't know if they waited for the counter notification to go through. Normally, it would be the person who is alleging the infringement brings the suit, right? But in this case, it was T. Greg against Stone and Dropbox Inc. and the Sons of Confederate Veterans. In their complaint, plaintiffs allege that the movement defendants violated the copyright infringement takedown provisions of the DMCA and seek damages for the movement defendants' alleged misuse of the takedown procedures and a declaration that Dropbox should not abide any copyright claims by defendants. As plaintiffs expressly state in their complaint, plaintiffs do not seek damages against Dropbox, and Dropbox is only named as a defendant to the extent its presence is necessary, quote, to achieve complete relief, which is, that's code words for Jay Woolman is trying to forum shop, which is looked down upon by the court. Jay Woolman knows that. Jay Woolman is a shame for display of attorney. Argument. This court lacks personal jurisdiction over defendants Ronald Kevin Stone, North Carolina Division, Sons of Confederate Veterans, Inc. Under Rule 12b2 of the Federal Rules of Civil Procedure, once a defendant affirmatively challenges the court's personal jurisdiction through a motion to dismiss, quote, the plaintiff bears the burden of demonstrating that jurisdiction is appropriate. Schwarzenegger versus Fred Martin Motor Company. Whereas here, the defendant's motion is supported by declarations offering specific evidence refuting minimum contacts with the forum state, plaintiffs may not, quote, simply rest on the bare allegations of its complaint to meet their burden of showing jurisdiction. Pursuant to the federal rules, this court applies California state law to determine whether personal jurisdiction exists over non-resident defendants. Federal Rule of Civil Procedure 4K1A, explaining that service of a summons or a waiver of service establishes personal jurisdiction over a defendant, quote, who is subject to the jurisdiction of a court of general jurisdiction in the state where the district court is located. Quote, because California's long-arm jurisdictional statute is coextensive with federal due process requirements, the jurisdictional analyses under state law and federal due process are the same. For a court to exercise personal jurisdiction over a non-resident defendant, that defendant must have at least minimum contacts with the relevant forum, such that the exercise of jurisdiction does not offend traditional notions of fair play and substantial justice. Personal jurisdiction under the Due Process Clause may be general or specific. In the present case, plaintiffs are unable to meet their burden of showing that this court has either general or specific jurisdiction over defendant Stone and NCSCV. First, it is clear that plaintiffs have no basis for asserting that general jurisdiction exists over the movement defendants. With respect to a corporate defendant, general jurisdiction requires affiliation so continuous and systematic as to render the foreign corporation essentially at home in the forum state, comparable to a domestic enterprise in that state. Indeed, only in an exceptional case, this may be an exceptional case, but not in the same way. Not in the same way, will general jurisdiction be appropriate over a corporation in a place other than its place of incorporation and principal place of business. For an individual, the paradigm forum for the exercise of general jurisdiction is the individual's domicile. Otherwise, an individual defendant may be subject to general jurisdiction only where he explicitly consents to the court's jurisdiction or has been served with process while in the forum. So if they could get Ronald Stone in California and serve him, jurisdiction exists. But if he's not in California, if they serve him in North Carolina, well then no, it doesn't. Here, NCSCV and Stone simply do not have the continuous, systematic, and pervasive contacts with California to exercise general jurisdiction. Defendant Stone was served with process in North Carolina, not California, and as discussed further below, the movement defendants have not consented to jurisdiction in the forum. With respect to specific jurisdiction, the theory set forth in plaintiff's conclusory allegation of personal jurisdiction in paragraph 16 of their complaint was soundly rejected by this court in Doe versus Geller. The facts of the Doe case are strikingly similar to the circumstances of the present action. As in this case, the plaintiff in Doe asked this court to exercise personal jurisdiction over non-resident defendants with respect to the plaintiff's claim that the defendants misused the DMCA takedown process based on the defendant's submission of a takedown notification to a service provider with a principal place of business in Silicon Valley, California. Uh-oh! Did somebody else already try to forum shop based on the third party? Jay Woolman, you fucking idiot. Did somebody else already think of this brilliant strategy? And did you just ignore it when you made your complaint, you dummy? This is the chicken shit lawyering that no one likes. What a waste of time. What a waste of the defendant's resources this is. God, I hope they rape you for fees. I hope they do. They probably won't. They'll probably just dismiss your case and laugh at you. But I hope they go after you for fees on this. It's such a scumbag move. Hi, we're going to force you to hire a lawyer all the way across the country. Because of a bogus legal action. All right, sorry. In analyzing and ultimately dismissing the plaintiff's argument, quote, that defendant's legal act of sending the takedown notice to YouTube in California is sufficient to establish personal jurisdiction in California courts, this court set forth the following well-established framework for evaluating personal jurisdiction. All right, here we go. The Ninth Circuit has established a three-part test for determining when specific jurisdiction may be exercised. 1. The non-resident defendant must do some act or consummate some transaction, oh baby, with the forum or perform some act by which he purposefully avails himself of the privilege of conducting activities in the forum, thereby invoking the benefits and protections of its laws. The claim must be one which arises out of or results from the defendant's forum-related activities, and exercise of jurisdiction must be reasonable. The Ninth Circuit has since expanded the first prong, also known as a purposeful availment or purposeful direction requirement, quote, applying different purposeful availment tests to contracts and tort cases. Purposeful availment in tort cases is analyzed under the effects test from Calder v. Jones. If you've been following your boy Zach's case, Calder v. Jones has come up quite a bit. As we have previously, I think, maybe I might be transplanting that in my brain now, but I'm pretty sure it did. As we have previously recognized, Calder stands for the proposition that purposeful availment is satisfied even by a defendant whose only contact with the forum state is the purposeful direction of a foreign act having effect in the forum state. Based on these interpretations of Calder, the effects test requires that the defendant allegedly have 1. Committed an intentional act, 2. Expressly aimed at the forum state, and 3. Causing harm that the defendant knows is likely to be suffered in the forum state. Personal jurisdiction may flow from a single contact with the forum state if the claim arises out of that particular purposeful contact of the defendant with the forum state. So Woolman's argument here is that defending yourself, using a DMCA takedown request to a service that is in the forum state is purposeful availment for the purposes of the Calder effects test, because that DMCA takedown passes the effects test of Calder. Obviously, the Sons of Confederate Veterans disagree with that analysis. I do too. The fact that Dropbox is in California doesn't mean you're directing the act to California to do a DMCA takedown notice. Because if they could file the DMCA takedown notice in North Carolina, they would. There's just no possible way to do it. And copyright is effectively a federal question. That's why all copyright claims happen in federal court. It's a federal question. Because This court would not have diversity jurisdiction over this because Duchette and Stone are both from North Carolina. So this would be a North Carolina thing, but for the federal question, because they don't have complete diversity of the parties. So the federal question makes it a federal case. So the question then is it North Carolina federal or is it California federal? They use the DMCA takedown, but that's a federal statute as well. It's not like it's specific to California. They're not using the DMCA to ask California to take down the infringing material. They're not relying on the protections of California. They're relying on the protections of the federal government. So this is a failure of the effects test of purposeful availment. It's crafty to try and do it this way, but it doesn't work that way because you're not engaging in protections of the forum state. You're engaging in protections of the federal government that through a company that just happens to be in the forum state. Does that make sense? I hope so. The court in Doe articulated its doubts as to whether plaintiffs could demonstrate purposeful direction or availment under the Calder effects test, and especially emphasized the lack of evidence in the third factor, explaining that the plaintiffs failed to adequately justify how YouTube's disabling of access to the plaintiff's video in California was an injury sufficient to establish personal jurisdiction over defendants in California. So here we have a similar case in Doe, because Doe was a YouTube takedown request, right? And so then they sued in California on the theory that YouTube is in California, not that the plaintiff was in or that the defendant was in California, but that the plaintiff requested or had a video taken down by the defendant, and because YouTube was involved and they used the YouTube DMCA process to take down the video, that created an injury. All right? And this court rejected that because of course it did. Just like in Sargon's case, California is not going to have jurisdiction over every DMCA takedown just because a lot of Silicon Valley companies exist in California. That would be really irritating. It would also fill up the California courts. Like, imagine if everybody brought suit on every DMCA takedown request, California courts would never recover. Okay. The court noted instead that, quote, plaintiffs' claimed injuries are more likely to be suffered in Pennsylvania, the plaintiff's residence. The Doe decision was ultimately not based on purposeful direction and was not instead premised on the grounds that exercising personal jurisdiction would be constitutionally unreasonable. And the question here is, does Duchette suffer damage in a different state because of DMCA takedown from a North Carolina organization about North Carolina affairs to a North Carolina audience was taken down? Does Greg suffer damage in California, or does he suffer the bulk of his damage in North Carolina in his home state? Of course, the answer is North Carolina. Any idiot could figure that out. It's a shame that Jay Woolman can't. While exercising jurisdiction here, the Doe decision was ultimately not based. Okay, I did read that. While exercising jurisdiction here would also be unreasonable under the third prong of the jurisdiction test for many of the same reasons the court articulated in Doe, as further discussed below, it is important to first emphasize that in this case, the purposeful direction analysis offers an additional basis for dismissal for lack of personal jurisdiction. Here, the substantiated facts supporting defendants' purposeful direction into California are non-existent. Plaintiffs' conclusory allegations that the movement defendants are subject to California's jurisdiction because A, the sending of the takedown notice at issue was purposefully directed and expressly aimed towards California, and B, the movement defendants consented to personal jurisdiction by using Dropbox's DMCA form and submitting its complaint to Dropbox fall apart upon closer inspection. First, plaintiffs assume that the movement defendants were aware that NCSV's electronic takedown claim was processed by Dropbox in California, despite the facts that the Dropbox form includes no indication that will be transmitted to California, and the fact that Dropbox maintains 10 other offices outside of California and over 2,000 team members worldwide. So there's a question. Which of the 10 offices processes their DMCA claim? We don't actually know. I have no idea. See Doc 1-5 declaration of Ronald Kevin Stone. The move-in defendants believe that plaintiffs may have made this speculative jump from Exhibit 3 to their complaint, which states that Dropbox maintains a San Francisco mailing address for receipt of hard copy DMCA counter notifications. The fact that DMCA counter notifications can be sent by mail to a California address, however, fails to show the move-in defendants were even aware that their electronic submission of their takedown notice was directed towards Dropbox California-based personnel, much less that they expressly aimed their conduct toward California. Now, we talked a lot about aiming your conduct towards something in Richard Myers' case, right? There's a difference between filling out a form online and dialing an area code for an organization. In Richard Myers' case, Mark Wade picked up and called a Texas, there's a lot of differences. He called a Texas company to interfere with a Texas contract between a Texas company and a Texas resident. In this case, they engaged in a DMCA counter notice, or a DMCA notification. They did it online. They didn't dial an area code, and they're not interfering with a California matter. It'd be a different question if T. Greg was a California attorney and he was talking about California thing, and the Sons of Confederate Veterans intervened over the California business that was going on. That isn't what occurred. It was all North Carolina except for the Dropbox. So there's some pretty important differences there. But let's see here. Footnote says, indeed, the express aiming requirement is more typically established, quote, when the defendant is alleged to have engaged in wrongful conduct targeted at a plaintiff whom the defendant knows to be a resident of the forum state, a scenario that is obviously not the case here, where every party except Dropbox resides in North Carolina. In contrast, in Doe, the takedown notice was submitted to a California-based facsimile number, certainly a clearer indication to the Doe defendants as to where the notification was ultimately directed. Nevertheless, concluding that it would be unreasonable to assert jurisdiction over foreign defendants in a suit brought by a Pennsylvania resident over an allegedly tortious fax sent to a third party in California. Yeah. They're not trying to damage anybody in California. Even if you determine they're trying to damage T. Greg specifically, he's in North Carolina, and they're directing the damage would be directed to North Carolina, not towards California. Plaintiff's second asserted basis for personal jurisdiction, defendants' consent to jurisdiction based on their use of Dropbox and the takedown notification process, is likewise baseless. Although plaintiffs were required to consent to the jurisdiction of a federal district court before submitting the counter notification, defendants had no reciprocal obligation under the DMCA. Okay. So notably, the statute requires a subscriber within the United States who is issuing the counter notification to consent to jurisdiction of the federal district court for the district where the subscriber resides, not where the service provider is located. So even if you use the DMCA takedown statute, the counter notification says that only the counter notification. So in this case, T. Greg would be the one submitting to the jurisdiction of the federal court, and he would be submitting to the jurisdiction of the federal court where he resides. But in sending the original notification, you're not submitting yourself to the jurisdiction of the federal court under the statute. So that's a pretty important distinction. Quote, the DMCA provides explicitly that internet users such as Sapient who wish to rebut a takedown notice must consent to the jurisdiction of a federal district court, but the statute does not require copyright owners who send takedown notices, such as the defendants here, to consent to personal jurisdiction. That difference must be viewed as intentional. If that result seems asymmetrical and unfair, then the problem should be resolved by Congress, not this court. As the party seeking to invoke the jurisdiction of this court, it is plaintiff's burden to demonstrate the move-in defendant's purposeful direction towards California, a burden they have not and cannot meet. This is true because even if the move-in defendant's electronic transmissions to Dropbox regarding plaintiff's posting and use of the entirety of Stone's letter constitute purposeful availment, a conclusion defendants emphatically dispute. Exercise of jurisdiction over the move-in defendants is constitutionally unreasonable. An evaluation of the reasonableness of exercising personal jurisdiction over the move-in defendants demonstrates that each of the factors identified by the Ninth Circuit, as set forth below, weigh against jurisdiction. So they're going to go through the Ninth Circuit's factors. This is in the Ninth Circuit, remember. So they're using the home court's factors against jurisdiction. Number one, the extent of the defendant's purposeful interjection of the forum state affairs. So even if they determine that the DMCA takedown was an interjection, it's a minimal interjection into the forum state's affairs. Number two, the burden on the defendant of defending in the forum. That's a big burden, right? Roger Stone would have to travel across the country. SCV would have to travel across country. They'd have to hire counsel in a state that is not their own, and that would be a big burden. And all of the witnesses that would be brought in this case would be in North Carolina, not in California, except for maybe one idiot from Dropbox. The extent of conflict with the sovereignty of the defendant's state, that's going to weigh against them because this is a North Carolina matter. Everything about this is relevant to North Carolina and no one else. For the forum state's interest in adjudicating the dispute, North Carolina would love to adjudicate a dispute between its residents, but the forum state here is California. California has no interest in resolving a dispute between two North Carolina residents over a letter sent to North Carolina people and it's stolen and published to other North Carolina people. California doesn't care. 5, the most efficient judicial resolution of the controversy obviously would be in North Carolina. 6, the importance of the forum to the plaintiff's interest in convenient and effective relief. North Carolina has the highest importance of the plaintiff's interest because he's from North Carolina. California doesn't care about a North Carolina resident. And 7, the existence of an alternative forum. Well, I'm pretty sure North Carolina is an alternative forum. First, as discussed above, the move-in defendant's interjection to California was minimal and only consists of the electronic submission of the takedown notice that was presumably received by Dropbox's copyright agent in California. Holding that the interjection into California's this is Doe again, into California through the takedown notice was not substantial, especially given that it was not aimed at a California resident and that the smaller element of purposeful interjection, the less jurisdiction is to be anticipated and the less reasonable is its exercise. Second, litigation in a forum far removed from move-in defendants and plaintiffs' residents is burdensome. Although the move-in defendants have retained California counsel to defend them in this action, the selection of counsel does not mitigate the inconvenience to the move-in defendants of ongoing legal proceedings across the country. As plaintiffs' claims are premised on the move-in defendants' good faith beliefs and knowledge prior to the submission of the takedown notice, move-in defendants and potentially other witnesses and officers involved in NCSCV will need to be substantially personally involved in the California litigation and ultimately testify in proceedings in the forum state should this matter move forward. The third factor also cuts against the jurisdiction, as this forum's sister state of North Carolina has a greater interest in litigating the dispute. I just said all this stuff, which merges into the fourth factor, California's interest in adjudicating this dispute. Dropbox is the only California resident as issue here, and as plaintiffs acknowledge, they seek no damages from Dropbox and make no real allegations of wrongdoing by Dropbox. Counsel is unaware of any attempt by plaintiffs to date to serve Dropbox or secure a waiver of service from Dropbox. So we don't even know if they've served Dropbox yet or if they even intend to. Let's see. Next, where were we? California thus has little interest in adjudicating this case where the only substantive claims involve non-residents. Yes. It has nothing to do with the state of California. With respect to the 5th, 6th, and 7th factors, it is clear North Carolina would be an appropriate alternative forum and the more efficient forum for judicial resolution of this controversy, since the witnesses, evidence, and substantive parties to the dispute are all located in North Carolina. The movement defendants struggle to imagine any reason that California may be important to plaintiffs' interests in convenient and effective relief when the parties and witnesses are located in and reside in North Carolina. That's because the plaintiffs are idiots. And they're malicious, and they think that the Ninth Circuit will go against the mean wastists of the Sons of Confederate Veterans. Let's see here. See, again, this case Doe, which is just devastating. Just devastating to Woolman's stupid pleading, noting that a plaintiff's home state is the preferred forum for a plaintiff when a plaintiff can establish personal jurisdiction over defendants in Section 512F cases. Accordingly, the reasonableness factors in this case weigh overwhelming against jurisdiction. As this court has already explained in Doe, plaintiffs' asserted basis for personal jurisdiction leads to unreasonable, even if unintended consequences. If plaintiff's theory of jurisdiction were upheld, then the Northern District of California could assert jurisdiction over every single takedown notice ever sent to YouTube or any other company in Silicon Valley. The movement defendants thus respectfully ask the court to apply this district's well-reasoned and persuasive opinion in Doe to the present analogous circumstances and dismiss the complaint against movement defendants for lack of personal jurisdiction. So there you go. So then they argue in the alternative, oh, this is almost done. We're going to do it. I'm not going to go through their declarations. I thought this was a longer section, but the alternative is forum nonconvenience. In the alternative, this court should dismiss or transfer the case to U.S. District Court for the Middle District of North Carolina on the basis of forum nonconvenience. Because personal jurisdiction is woefully deficient for the reasons set forth above, defendants maintain that dismissal on jurisdictional grounds is a proper remedy in this case. However, should the court conclude a less restrictive means of addressing the unfairness of jurisdiction is appropriate, the movement defendants request transfer to North Carolina. See Burger King versus Rudeswicks, explaining that the inconvenience of a forum can often be addressed through a change of venue when the party has minimum contacts with the forum to litigate there. For the reasons discussed above, the Middle District of North Carolina is a proper forum for this matter should the court decline to dismiss the complaint against the movement defendants on personal jurisdiction grounds, explaining that to grant a motion based on forum nonconvenience, the court must find that there's an adequate alternative forum and the balance of private and public interest factors favor dismissal or transfer. Then they have their conclusions. They request the court grant its motion to dismiss for lack of personal jurisdiction. If, however, transfer is deemed proper remedy by the court, Middle District of North Carolina is the appropriate forum and venue for this action. So there you go. That is the thing here. Certificate of service. We've got Kevin Stone here. What is this? Served Randazza. And then the declaration of Ronald Stone to support is here. I live in North Carolina. I've never even heard of California. I guess we could burn through this quick. I'm over 18 years of age and suffer no disability as a witness. I have personal knowledge of the facts stated herein, and I'm competent. I'm a resident of North Carolina. I've never lived in California, do not own any property in California. I do not have any personal property or bank accounts in California. I've never maintained a telephone listing, mailing address, or post office box in California. I've never maintained an office in California. I'm the division commander of the North Carolina Division Sons of Confederate Veterans, Inc. I have personal knowledge regarding NCSCV's operation in my role as an officer of NCSCV. NCSCV is a North Carolina registered nonprofit corporation organized under the laws of North Carolina. North Carolina Sons of Confederate Veterans is headquartered in Sanford, Lee County, the great general, North Carolina. NCSCV has never had an office in California, does not maintain a registered agent in California. NCSCV does not own any real property or personal property in California, does not maintain any bank accounts in California. NCSV has never had a telephone listing, mailing address, or P.O. box in California. NCSCV does not conduct any of its operations in California. It does not have any officers or members in California. With the exception of the legal counsel, NCSCV engaged to defend it and myself in the present litigation, NCSCV has no representatives or agents in California. On December 2nd, 2019, plaintiffs posted the entirety of a letter document I created for distribution to NCSCV's membership regarding ongoing litigation in state court in Orange County Superior Court in North Carolina concerning a monument honoring students and graduates of the University of North Carolina at Chapel Hill who served in the Confederate Armed Forces onto plaintiff's Twitter page using Dropbox. On behalf of NCSCV, its Chief of Staff Matthew McGuigan electronically submitted a notification of claimed infringement to Dropbox using Dropbox's DMCA complaint form concerning plaintiffs copying and use of the entirety of the NCSCV letter. Mr. McGuigan took a screenshot of the electronic DMCA complaint form prior to submission, which captured some of the language NCSCV included in its complaint. Mr. McGuigan received an auto-generated communication from noreply@dropbox.com that Thomas Gregory Duchette had submitted a counter notification in response to the DMCA notice. NCSCV later elected to withdraw its DMCA complaint against plaintiffs and submitted a support request to Dropbox online support page to vacate the complaint. Mr. McGuigan received a response acknowledging receipt of that request from support@dropbox.zendesk.com. So they even dropped it and he still sued? What a giant vagina this guy is. What a giant pile of trash T. Greg is. Think about that. Like, you sue for the takedown notice after they dismiss it voluntarily. They say, you know what? We were wrong on this. We'll take it down. Then you're going to sue them? Oh my gosh. Just absolute idiocy. They complied with the DMCA. They complied with it. NCSCV did not receive an email response from Dropbox confirming that its DMCA complaint had been withdrawn. The help request was marked solved, however, when NCSCV's Chief of Staff visited Dropbox's support webpage to check the status of its request. NCSCV and its representatives did not speak to any Dropbox employees or personnel over the telephone regarding its DMCA complaint. The only communications NCSCV and its representatives received from Dropbox appeared to be auto-generated replies. That's it. So there you go. So they don't have any explanation involved at all. So there you go. That's it. That's the whole of the order there. Gosh, what an insufferable pile of broke T. Greg is. I hope they lose. It'll be so funny if they lose. Oh my gosh, here we go. Solo. We have a couple donations here. We have one from Anonymous, and then we have one from T. Greg can't raise over 10K and still bankrupt. I have a feeling Dropbox might remove that name and that donation, but we'll see. I appreciate it anyway. Thanks, guys. Thanks for the donations. Oh my goodness. But yeah, after reading that, I feel pretty comfortable saying that I'm guessing they're going to relocate that to North Carolina, and I don't know that T. Greg's going to win this case. Did they do a good faith, fair use assessment in making their takedown request? I don't know. But they could probably assert that they did. They're just a bunch of dumb racists, right? Like, that's going to be the whole premise of the case, is that they're dumb racists. They don't know what they're doing. So then they decided that he did a copyright violation. They submitted a DMCA takedown, and then he submitted the counter notification, and then they withdrew. What are they like? What is T. Greg going to argue that they did, that he deserves from this, that the damages that he incurred? This is a really ridiculous lawsuit. It's a waste of the court's time. And the unfortunate thing is, the plaintiff is an attorney who should know better, but he's using this to improperly boost his own reputation. That he's actually filing suit for personal gain that has nothing to do with the alleged damage of the copyright. It's exactly what Akilah was doing, only scummier because he's a white male. That makes it worse automatically. I called it Dropbox. That's the liquor, sorry. Yeah, GoFundMe did change its name to Dropbox on the stream just for this. Just for this. No, GoFundMe can do everything. Haven't you guys learned? Haven't you guys learned? All right. But that's what I got for today. I'm going to go ahead and read through the super chats. We'll just have to see what Doucette does here. And Jay Woolman. Oh man, it's going to be a shame laughing at that idiot. All right, let's do the super chats and justice chats, and then we will. Yes, how Twitch became Twitter. You guys are asking if I can do Twitch. Gosh, I don't know. I gotta get up super early and drive to the airport, which is 2 hours away. I'll do a little bit of Twitch, but no complaining. No complaining. I'll do a little bit of Twitch. Maybe 30 minutes to an hour tops, but that's about it. Okay, anyway. So Knight of Hopex says, fascism is a two-edged sword, eh? Those who live by criminalizing speech will have to live with the consequences also. It's just as well. The only way these people learn from having their own stupidity turned on them. Heaven help those clowns in prison. Next is Bad Dragonite. It says, screw coronavirus. If you want a real depressing story, my town finally legalized alcohol sales only to have every place sell literally just beer. Oh, rip. These Hands says, nothing happened in Sargon's case, which means it has something in common with Tiananmen Square 1989, where nothing also happened. Kara says, this is super late, and I doubt you remember this, but a few days before the hearing that Chup threw out the TI, I super chatted that Chup was lazy and wanted this gay anime shit out of his court. You gave me partial credit. I'm appealing your ruling, Nick. No, I'll give you full credit. You win that appeal, Kara. You do. Knight of Hopex says, legal proposition for you. Well, I'm more interested in the illegal propositions. If there exist people who can only get it up to hentai, who have duties of sexual affection to a spouse and or a desire to procreate, doesn't that necessarily mean hentai is useful art under the definition of copyright? Hentai is useful art, period. Bad Dragonite says, you may not want to celebrate something being American too much just before going to Canada. It might be hate speech. These Hands says, you want to talk to Josh about the RuneScape terrorist situation? Try asking Count Dankula. He did a stream where he interviewed the guy. A good place to start if nothing else. Bad Dragonite says, Zuby Music just got yeeted from Twitter for calling someone dude, as that was deemed to not be properly respecting personal pronouns. Social media was a mistake. Kay says, wait, so he's suing someone because they DMCA'd something on Dropbox? This dude is effing bankrupt. Why on earth did he think taking a gamble on such a petty, stupid lawsuit was a good idea? Even if he has a chance at winning, this is absolutely batshit. Oh yeah, it's the dumbest lawsuit there is. Kay says, has there ever been a lawsuit episode of that My Strange Addictions? I feel like there are people who have a form of addiction to suing people. Russell Greer. Then again, if that show had someone like that on their show, they might end up getting sued by them. Bad Dragonite says, correction to last message. Zuby hasn't been yeeted yet. He's just being mass flagged for it. We're getting reports that social media is, in fact, still a mistake, though. Yeah, I think that's true. That's true. Lydia, you were exposed on the plane from Japan with coronavirus? No, live. Live. I drank the, look at this. I can't drink it anymore. It's been taken care of. So, but please don't coronavirus into oblivion. We need you, Lydia. We need you. Super Range 128 says, why do you hate Krillin? Because he's a wimp beta. I hate everything about Krillin. Oh my god. Just look at him. The best part of Dragon Ball Z is when Frieza kills him. Oh, it's such a good... Oh, talk about cooming. Krillin getting exploded. Mario Carter 13 says, Your Honor, the plaintiff doesn't even own a suit. Oh, no. 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 Good thing Sargon was the defendant there. Skagi Onsai says, Jeffrey Epstein late and Pete Buttigieg horror. Oh, no. Ben Frail says, postpone EVS and quartering our bro streaming. No. My show goes on when my show goes on. And if other people do stuff during the time, that's great. I hope they do well. Cargus says, I thought I was late and gay, but I was actually on time and hetero. Thanks for keeping me straight, Nikki. Hashtag late and gay Nikki. Rude. Samantha Schoner says, Osaka schools have been shut down from next week until April due to fear of spreading coronavirus. Here's hoping that I don't catch it. Stay safe. Don't catch the Wu flu. Don't eat bats or whatever. Ben Frail says, interesting article on Adam Waffen in Daily Stormer. Okay. Colo Sign says, donated 4 VIP tickets. Hope it makes someone's day. Me too. The Sean 23 says, apply the sacred ointment, Yamcha. No way. Grand Admiral Pepe of the Meme Empire says, you should skip the after party Saturday and drive 2 hours to Newmarket. Come party leap year style. See you on Sunday. Well, see you on Sunday. I won't have a car. Bad Dragonite says, we got to have a Rekieta EFAP crossover episode. Yeah, I'd love to do that. Sean23 says, Nick, you should interview a black lady in Japan who is doing law in Okinawa. Maybe a chance to learn how law works in Japan. Who's that? King DI says, since all cases seem to be taking a lot of time, are the courts just backed up or understaffed? Not enough judges? There are not enough judges. That is true. As for the courts being understaffed, no. It's just, there's just a lot of people. There's probably not enough courts, but not enough judges. I mean, really, that's what it is. We are something like 1,000 federal judges deficient of where we're supposed to be. Trump has been appointing a lot of federal judges, but we're still way behind. Mario Carter 13 says this lawsuit outlived his entire political career. Oh no. Fluffy Side Up says, Lemon Voice, I'm tired of these mother fudging mosquitoes on this mother fudging plane. Malik Foxen says, you think the context of that founding fathers discussion was they wanted to make fun of the media content the Reds would bring over from Europe while protecting copyrights? No. Yes. Maybe. Are you talking about my joke founding fathers discussion? No, I don't remember. Spectre06 Gaming says, change the screen so we can see Boomer. I'm sorry. Okay, I'm sorry. John Haynes says, have fun. I'll be in BC, but family obligations keep me from coming to KCC. Sorry to hear that, buddy. James Mansfield says, Spicer is nicer. It is. Gunnar Renee Oy says, I think Zuby got temporarily banned for dude. That's just a shame. Gelf Walker says, thanks, Nick. I'm feeling better now. More rum needed. Always. All right, guys. That's it. That's what I got for you today. I gotta go. I gotta do some quick Twitch thoughterry, and then I gotta go pack up and get ready to leave the country, and try and avoid the coronavirus. All right, guys, thanks for hanging out with me tonight. I hope you enjoyed the show. I'm not sure what the streaming is going to be like at Kitchener. I'm going to maybe try and do a stream tomorrow, but I can't make any promises. But I will announce it on Twitter and on YouTube if we're going to have something. So, let me hit this outro. Oh, there we go. Oh, there's the outro. I don't know if Drexel's coming or not. I have no idea. Lady Rackets is coming with me. That's the most important part. So I don't know if Drexel's going to make it or not. I haven't talked to him since the show, really. So, all right, guys. Well, that's not entirely true. He hung out at my house. I talked to him, you know. But since he was here for the show. Anyway. All right, guys. Y'all have a good night. Duchette's an idiot. Jay Woolman got embarrassingly wrapped up with an idiot. Or maybe he's just an idiot himself. It's hard to say. But we shall see. All right. Y'all have a good night. Peace. Peace.
Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an art bag, a bow, more of love rug. The spirits flow as the ones who get unemployed. So pour out a glass for the tea, post on Twitter as we hear Lost Planning tonight. From the white shores of Nam to the hills of Glenlivet, there's no one who explains the wrong better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, the guests are all planet folks, from Doug T to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Get unemployed, so pour out a glass for the tea, post on Twitter as we hear Lost Planning tonight. From the white shores of Nam to the hills of Glenlivet, there's no one who explains the wrong better than